The clerk will open the court.
Oh yay, oh yay, oh yay. The Honorable Court of Criminal Appeals is now in session.
We're ready to hear argument in PD number 0810-19, the state of Texas versus Ricardo Mata.
May it please the court, my name is Emily Johnson-Leo. The public safety exception to Miranda is not just a weapons exception. Miranda held that warnings about Fifth and Sixth Amendment rights and suppression of any unwarned statements were needed because of pressures of custodial interrogation, where police press their psychological advantages to get a confession. But in Quarles, the Supreme Court recognized that the balance was different, where there was something more than law enforcement at stake. It permitted unwarned interrogation, even of someone in custody, in order to neutralize a threat to public safety. And this rationale is not limited to guns or weapons, and neither is the language of Quarles. Instead, Quarles essentially created something akin to an exigent circumstances or emergency aid exception. And here that exception applied because the threat was still ongoing. When Investigator Perez asked questions aimed at rescuing a kidnapped teenager, they were still very much caught up and focused in on what was going on in order to save the life of that child. This all took place during the course of about 32-hour around-the-clock shift, where police first learned of a kidnapping and a ransom call, posed as a family friend and talked to the ransom caller, then real-time tracked his cell phone, followed his car, pulled him over, and when the investigator that he'd been talking to got there, they repeatedly asked him, "Where is the girl?" all before Mirandizing him. And this fell well within the public safety exception.
Counselor, was the appellant under arrest at the time of the questioning?
He was definitely detained. He was in custody. Whether he was arrested or not, maybe there's some leeway to decide that. He's standing at the back side of the patrol car, and he has been, the record is not developed for how long he's been there, waiting on the investigator that he's been talking to on the cell phone to arrive. But definitely it's a custodial type situation. There are at least 3 officers there at the scene. And the state was contesting custody, I believe, at the trial court level. But for the purposes of what the state is presenting now in the PDR, we're assuming that this is a custodial interrogation situation. The Court of Appeals was concerned about making the exception too broad if it were to be expanded beyond weapons. But it's really going to be circumscribed by the mere fact of the emergency, whatever is the threat to public safety that's going on. In other state cases that have applied this to kidnapping situations, the courts have sort of held that the threat ends when there was no longer a realistic possibility that they would find the victim alive. So in a situation when like a baby was left in the cold outdoors, there was snow on the ground for a period in which it was no longer possible for the infant to have survived, that was the period when that sort of emergency would have ended. Also, the exception is going to be limited by the fact that the questioning that the officers is doing has to be viewed objectively, has to aid in finding that victim. So, for example, an officer's questions about, well, have you ever been involved in human trafficking before? Or did you mistreat the victim when you had her? Those types of questions, because they aren't aimed at getting and finding the location of this missing kidnapped person, then they would not lead to, then the exception would probably not apply in that situation. Also, given that there are very few cases in Texas in which this exception has been applied, I think that's some evidence that people are not abusing, prosecutors are not abusing this exception, and it hasn't been used very much.
Counsel, is this just a kidnapping exception? I mean, is it just going to be limited to this type of situation, or can it be applied to any kind of ongoing crime?
Well, it wouldn't necessarily be any ongoing crime, but I think it would be, there could obviously be other public safety risks, concerns, and risks to the officer. That, like, say, for instance, an officer who plans to frisk a defendant, asking, is anything in your pockets going to hurt me? That could be a concern, an immediate concern for safety on the part of the officer. So it wouldn't necessarily be limited to that.
Right, but that's what I'm saying. Like, so it's like, we know quarrels is guns or weapons, and this is kidnapping. Is that it? Or are we going to add other ongoing crimes to the list?
I think other ongoing emergencies, other evolving type situations, this is not unlike the confrontation, public safety concerns and of an ongoing police emergency that police are responding to, trying to neutralize threats there. I think that's kind of an analogous situation that the court could look at. So, but the fact that even across the country, this exception is not used very much, simply because the questions have to be limited and the time period in which the emergency lasts is not, forever. So I don't think there's a huge risk of this expanding too much.
So are we assured that the only question, since there are 3 officers, were only where is the girl? Where is the girl? So we don't have any of those questions like, did you beat her up? Did you, sexually assault her? We don't have any of that. We just have, where's the girl?
There's not a transcript of what the conversation was, but yes, no one is saying that the questions were, what did you do to her when you had her? Things like that. Yes, it was, where is the girl? They were very insistent. You know where she is. Tell us where she is. Those kinds of questions. Yes, and he, from the description of what happened, he was also like directing them, like got in a car with the officers and was directing them where to go to find the girl, where she was located at his friend's house. So it's like, yeah, do I turn left or right? Those also kinds of questions, but again, aimed at locating and finding her. Another thing to note is that a defendant in a given case could still establish coercion, even if there's a public safety exception. The exception doesn't absolve police misconduct or trump the Fifth Amendment. So there still has to be voluntariness. This is
was his counsel, was his answer necessary to convict him or just to rescue the girl?
As it happened, when he tells the police and reveals that he knows the location of the victim, that is certainly incriminating. And certainly the response to these questions, it was interrogation. I
guess my question is, it was interrogation without Miranda. Why not just not use the statement and go forward with the case without the statement? Then where's the downside?
I think in this particular case, there was also a challenge to the written statement that he gave later on at the station house. And so the state, and that ended up being suppressed as well. And so the state, needs some evidence to go forward in the case. I think they had perhaps the victim's testimony as well. But this was very good evidence to show that at the time he was closely connected to the offense and was able to take officers directly to where she was.
So it went beyond trying to find out where the girl was and rescue her. I mean, it was good evidence that you needed to convict him without Miranda, right?
And there often will be sort of a dual purpose that officers have when they're asking these questions to find the girl, and later on they're going to be trying to develop a case. So I'm not saying that it's pure, their only motive in this situation or in any sort of objective situation would be just to find the missing person. But, you know, that was sort of the case in Quarles too. Although it started out as an investigation of a rape case, he ultimately was prosecuted for the weapons possession. And, you know, when he goes into the store and sees the empty holster, you know, he's in New York, he knows it's an offense to have a weapon without a permit. And so at that moment, you know, the officer too could be concerned for safety and in his role as prosecuting a crime. But nevertheless, the court held that the social cost of suppressing statements that are unwarranted in that situation is just too high. And I think the same goes in this case. Well, unless there are no more questions, I'll go ahead and reserve the remainder of my time.
Thank you, counsel.
Who may please the court. My name is Mauricio Martinez, and I'm arguing on behalf of the appellee, Mr. Ricardo Mata. Listening to arguments by the state's prosecutor a few minutes ago brought up several issues that I wanted to bring to the court's attention. The court made some very valuable questions regarding the dual aspects of asking questions in regards to what was actually going on that night. I believe it was Judge Richardson that asked specifically what was the point of ascertaining those the answers to those questions when the defendant was being questioned on the side of the road. Even though the 13th Court of Appeals ruled that under the public safety exception, the questions regarding the whereabouts of the victims that were asked on the side of the road would be suppressed, the court actually did overrule the rulings by the original trial court in regards to the station house confession, statement of accused made by the defendant. The situation here is one that under the public safety exception that was created by the Quarles Court, if looked at it on a case-by-case basis, the facts of our underlying case create a situation where even though the police and the state's prosecuting office now may be arguing for a public safety exception based on the exigency of the situation and based on the potential danger to a victim of a kidnapping case, simply is not that clean cut. Like the state's prosecuting attorney informed the court, this was a situation that was involving multiple agencies and a few span of hours. The original case originated out of Zapata County, which is a neighboring county down here to Hidalgo County. The Zapata County Sheriff's Office reached out with the mother of the kidnapped victim to the Hidalgo County Sheriff's Office with this question of a man potentially in our county, the city of Mission, being the person who is holding a kidnapped victim. Now, the officers held on to that information. They required, they put forth a request for an exigency pinging location of a cell phone that was being used to make contact with the victim's mother. And they narrowed down the location of that ping location to a city here in here in Mission, which is a city in the county of Hidalgo. Using that information, they actually relayed that across to other officers that were in the scene, that were on location, and they sat on the house for, based on the record, several hours. Because of the fact that they sat on the house for several hours and eventually waited not only for the defendant, but for the pinging of the cell phone to leave the location before they conducted a traffic stop, the appellee's position here is that the exigency was slowly dwindling away. What ended up happening is you have Investigator Porras, Investigator Chavez, and a handful of other investigators for the Sheriff's Office who are part of the Major Crimes Unit. These are officers that, based on their testimony, the record is clear, are well versed in the legalities of what they can and can't do in terms of arresting somebody when they are at a certain location, when they're not at their home, and when they're going to be able to conduct a certain type of stop that's going to allow them to gain some testimonial evidence that's going to be used against them later on down the road. These officers put forth some testimony that showed the court that they sat on the house, they waited. Eventually, he got in his vehicle and he drove away. The record's not clear as to how long he was on the road for, but it was long enough for him. And by him, I mean the person on the phone. Again, at this point, there was no record showing that it was actually Mr. Mata that was the individual on the phone until later on down the road, once he was the only defendant to be found in the vehicle. But the important part here is the officers were speaking to somebody on the phone, and it wasn't until that individual indicated, I'm losing phone battery, that they decided they were going to conduct an investigatory stop. Not a stop based on probable cause because of a traffic infraction or any of that nature. It was a stop mainly because of the fact that at this point they felt they were going to stop gaining more evidence. Now, the reason why I discuss that and I label that as more evidence is because during the actual motion to suppress itself, the trial attorneys for both the state and for the defense argued about whether or not the original statements made over the phone to the, I guess you could call him undercover police officer who was pretending to be a friend of the family. Those were some of the statements that were originally brought and that were contested as to whether there was admissibility issues there.
Are you contesting the reasonable suspicion of the officers to stop the defendant, or?
No, Judge. I'm merely giving background information as to how we got here. The situation is this. The officers testified that at that point, they felt they had probable cause to detain the defendant. And based on their testimony and based on the record, it's clear that both officers testified that he was in fact in custody. They detained him for the purposes of conducting an investigation as to whether or not he was in fact the person that was kidnapping this child. Now, the situation is this, though. They didn't make that decision to stop him out of exigency. They didn't make that decision to stop him out of this threat or this fear that the child was in fact in the vehicle on the brink of death. They made that decision because they knew at this point they were no longer going to be allowed to collect any more evidence. The same way that they made the decision to sit on the house and let the exigency expire, as opposed to what actually would have been allowed at that point for them to have conducted a warrantless raid of the house if they were so concerned for the child victim's safety.
But didn't the Supreme Court in Quarles acknowledge that officers might have multiple motivations for asking this kind of a question, a public safety type of question? And it didn't seem to matter to them that an officer might also have a motive to discover evidence in addition to the public safety question.
And Judge, I agree with you. And that's kind of what I'm trying to relay to the court here. The situation is this. They were attempting to collect more testimonial evidence by questioning him without Miranda. Because of the fact that the child was in fact not in the vehicle, which they had under surveillance, so they would have seen somebody approach the vehicle, essentially smuggling the child away.
Well, counselor, wouldn't that have given them some concern if the child's not in the vehicle, that they need to know where she is, whether it's in the house or building or someplace else, and she's not in the vehicle?
I most definitely agree, Judge, which is why they would have had the premises for a warrantless search of the house itself and of the vehicle. They should have stormed the house. They should have come in, guns blazing. They would have been making the right decision to save the victim at that point. But instead, they made the decision to take a step back and investigatorily maneuver the situation so that they knew that they'd be able to conduct warrantless arrests. They'd be able to detain him. They'd be able to ask him questions at that point, merely for the purposes of conducting more testimonial investigation.
But why storm the Bastille if they don't know where she really is?
Right. Don't they lose a potential that they're now they're alerting the defendant that they're on to him, and that gives them a better chance to hide the child?
I would agree with you typically, Judge. The situation is this, though. The record is clear that prior to them making contact with the defendant's house, he had in fact called the victim's mother and said, not to defend any potential kidnappers, but he said, I'm only trying to get my money back. There was no clear and present danger that was presented by the testimony. So if the court essentially is believing the defendant that he may or may not be in possession of a kidnapped child, then we also have to give slight deference to his statements that day, which were, I just want to get my money back, in terms of, I didn't mean to kidnap this child.
Well, how does that give the police any information as to where the child is?
Well, at the very point, he was indicating that he was one of the people that was in charge of her. So he's indicating to the mother that the child at one point was in his possession. Now, later on down the road and through the record, we were able to ascertain that not only did he have possession of him, but his own live-in spouse was somebody who said, I don't want this person in my house. So in fact, if the officers had breached their residence, they would have made contact with not only potentially the victim, but also the defendant and also the defendant's live-in spouse, who would have indicated, in fact, she was here. She was in good, safe, in a good safety, good, safe manner before she was removed from the premises to the secondary location.
Counsel?
Yes.
Just want to make sure I understand. Your argument isn't necessarily that Quarles, doesn't cover this type of situation. You're just saying that there wasn't exigency. Like it could if there's real exigency, but you're saying that this isn't really exigent. Is that what you're saying or not?
Judge, I want to say that my argument is two-pronged. First, I'm saying that not only is this not covered by quarrels because of the lack of exigency, but additionally, by the reading of the 13th court in the Mata decision, along with all the other sister courts in the state, there has been an underlying reading into the quarrels decision that requires not only the exigency, but also essentially the weapons aspect of the exigency matter. If there is no...
But it also looks at public safety, not just
Yes.
weapons.
Yes, ma'am. However, everything that I pulled up during my research of this secondary brief that we submitted indicated that it seems to only be applied and rendered to be true when there is, in fact, a weapons offense apart and also with the immediate exigency. We have cases where somebody was stabbed, shot, or was currently bleeding out. And there's questions of where is the active weapon? How did we get to this situation? And those were admitted by the lower courts in the state because, again, the officer's safety was a first evaluation, followed immediately by what's considered to be the public safety. Now, here, it does seem like we're nitpicking because I'm arguing that rendering a decision that will very narrowly submit kidnapping victims to this underlying definition of the word public safety, in my opinion, becomes a slippery slope. We're gonna put the state in a position where the first door is gonna be open, where we're able to classify kidnapping victims and or human smuggling victims to a position where they are now classified as the public in terms of public safety. However, that's going to open the window then to the very next argument of any other victim of any other crime classified as the active, ongoing public in a crime, similar to...
Well, we have other cases where community safety involves other things besides weapons, like warrantless intrusions into buildings to find children. So
yes, ma'am.
So if that proposition is solid, then why wouldn't the same theory apply here? Public safety includes victims, children, for example, who are kidnapped or victims of sexual assault or human trafficking.
Yes, ma'am. And I believe that I addressed something similar to that in my brief. The situation here is that if we do end up getting in a position, and I believe the best case to look at would be the Mincy v. Arizona case, which is a Supreme Court case, if the officers feel that they're in a position where they're needing to make a life and death decision or the exigency has risen to the point to where they need to rescue someone, then they're able to cross and essentially violate what would be a Fourth Amendment issue as opposed to the Fifth Amendment issue. So obviously, I'm trying to tailor my argument here to the questioning being done in a point without Miranda, as opposed to someone's reservations or somebody's protections under the Fourth Amendment. Now, what I believe it may happen if we keep pushing this position here, this argument that because of the specificness of the situations around kidnapping and human smuggling, and I understand that Texas is in a unique position. We are a border state, and then even more specifically, the Hidalgo County, where I'm down here, we are a border county. Human smuggling is something that does happen. But if we open the door to allowing the victims of this specific case to be classified as a public safety issue, there's nothing stopping the state from classifying further victims of more types of offenses under the public safety exception. And unfortunately, that may be the slippery slope that leads to officers being allowed to, without Miranda, question defendants as to what happened in situations under the guise of questionings that are warranted around the idea of trying to save these victims. You may have somebody charged, for example, with an intox manslaughter, and an officer may come in, start asking questions as to where they were coming from, merely so they can ascertain whether there are any additional victims down the road. You may also, and so now you start getting admissions of, okay, they were operating a motor vehicle, they were coming down this public roadway. So you start having these elements of multiple crimes start to be met by these admissions being elicited, this testimonial evidence being elicited by officers on the streets, because they're going to be able to bend their arguments and they're going to be able to articulate at trial that their questioning was merely to ascertain whether or not there was in fact a public safety issue.
Well, that's when we look at the specific questioning, right?
Yes, ma'am.
Yes.
Yes, ma'am. And you, I know you did ask a question earlier of the state prosecuting attorney as to what in fact was the questions that were done on the side of the road. And even though the questions themselves did stem around this idea of where is the girl, they had a conversation with the defendant similar to, and it was a statement made in Spanish, and it was roughly translated for the record along the lines of, "We already got you, just tell me where the girl is." At that point, again, as the state prosecuting attorney made reference to, maybe the defense at the trial level could have made an argument that by essentially trying to convince the defendant that he had no other way to move and no other where to go, it may have become coercive in nature, and therefore the Fifth Amendment may or may not have applied regardless of Miranda. Those questions were testimonial in nature because it was beyond the nature of trying to find the victim. It was, in fact, as I had stated earlier, a situation where these officers had found a way to maneuver around this idea of having to wait and watch. And when they hit the wall and they realized they weren't going to get any more testimonial evidence from him off of the cell phone that he was using, they needed to go ahead and just stop him at that point.
Do you have a position on the second statement, whether or not it was tainted because of this initial encounter? Because that was fully Mirandized, correct?
Well, there was arguments as to whether or not there was a proper Mirandizing there, Judge. There was a Mirandizing done by one officer earlier that morning or earlier that night, if I may, because all this stemmed after midnight. And so there was a situation where one officer came in, Mirandized the defendant, left, the Mirandized was left, the defendant was left there in his cell overnight. He was up all night. And then eventually the following morning is when the second officer showed up and says, "My understanding is you have been Mirandized. Let's go ahead and type up a statement." And then after that statement was typed up is when he was once again, quote unquote, properly Mirandized. And then
Are the warnings on the face of that statement?
It was on the typed up statement, yes, sir. But again, it was indicated by the record. This is a substantial compliance issue, Judge, that I believe that the 13th Court of Appeals ruled was proper already, which is why that second statement was already admitted. But it was one of the situations where the officers essentially, in my opinion, took advantage of an individual who maybe was not as educated as they were. They let him stew all night, and in the morning had him recite what their opinion was a statement of accused, where the officer himself even testified was not a verbatim version of what actually happened that night. In fact, it was his mostly accurate depiction of what happened, but it was adopted by the defendant with a signature at the end of the statement itself. Now, there was some cross-examination as to whether or not everything was included. Not everything was included, but it was adopted because it was signed. And again, it's a situation where, I assume most defense attorneys across the state would agree with me, Miranda should have been given at the beginning of the statement and not just merely as a formality at the end of the statement to make sure that that substantial compliance was actually complied with. Now, Your Honors, the situation is this: if my overarching point here is that if we're looking at multiple states across the country, multiple districts across the country, there seems to be this idea that there is a rescue doctrine that gives excuses to the Miranda-less questioning of defendants. So if you get into a situation where the exigency exists, these officers should have been allowed to ask these questions to either locate victims or locate potential evidence. The appellee's position here is the exigency did not exist in the case at hand. And because of that, quarrels should not be stretched and extended beyond the position that it has already been understood and applied by all the other sister courts here in the state of Texas. When there is no weapons involved, there is no immediate danger to officers involved, and there is no exigency to the public immediately around the situation, there should not be any reasons why the officers cannot take a minute to just Mirandize someone properly and warn them of their proper Fifth Amendment rights to remain silent and not self-incriminate. And so, unless there's any other questions from this panel, I'd like to take the opportunity to just pray that this court upholds the ruling of the 13th Court of Appeals and affirms that the statements made on the roadside were improperly gathered in violation of Miranda.
Thank you, Counselor.
I do have a question because I don't understand how there would not be an exigency with a kidnapped victim still somewhere out there. I mean, are you saying that the victim herself is just not a member of the public or what?
Not necessarily, Your Honor. What I'm trying to say is I don't want this court to characterize victims of an active ongoing case as the general public. which is what I feel is the recipient of the public safety exception. Now, the courts across the state have interpreted the public safety exception to apply in situations where there is an active weapon being used and that may be used again in an active situation regarding either officer safety, having to do with officers locking down knives, guns, things of the sort, or when there is some sort of immediate danger to the vicinity of that weapon, similar to one of the cases, I believe it was a Solis case that I cited to in my case. In that situation, there was a gun that was left similar to the Durham case. These weapons were left in locations, whether they were trash cans or whether they were holding containers. But the public is a lot bigger than just the specific victim of the crime at hand. The public is these unsuspecting third parties that may now become members of this case by stumbling on a weapon, by using a weapon, by somehow being harmed by the potential third party co-defendant that may come in later if they were to find that weapon, similar to the arguments made in the Quarles Court discussing whether or not that gun had been left in the supermarket, although it was at night, could have been found by a patron the following morning, or could have been found by a co-defendant, even though there was no mention of one in that same encounter. So for those reasons, what I'm trying to argue is, even though a victim of any case is a normal person in the public, I don't want them to be categorized as the only recipients of this. I want the public to be the public and the first and second party of a crime to be independent of that, so that there is no stretching of this narrowly tailored exception. Thank you.
Thank you, counsel.
Thank you all. Everybody have a good day.
I want to address, I guess, first the idea of public safety and whether or not victims of crime, if they're already sort of identified ahead of time, can't be members of the general public. And I think that the right analogy here is this court's other sort of public safety cases, like and Judge Hervey's case that she was alluding to in Laney. Also uses that same terminology of public safety and the concern for public safety when they, when the officer goes into the trailer, when he sees a single boy in the trailer, it's already, a person that could be a victim of a crime. So I think that, again, because these other very similar doctrines, emergency, exigent circumstance doctrines, like the one recognized in Mincy, if you know that there's a person already, a specific person that could have been the victim of a shooting in a house, we don't say, well, that person is no longer a threat to the general public. I'm not going to go into the house to check on the safety of that one person. So I think those sort of analogous doctrines could be helpful in addressing that. Also, it's not that certainly the Miranda warnings only take 30 seconds, right, to read, but that's not the issue. The issue is that when Miranda warnings are read, sometimes the defendants will insist on their rights and will not speak. And so Quarles recognized this and said that the social cost is just too high, and that we want to give officers in when they're trying to neutralize a threat to public safety to be able to get to the most efficient answer, the most logical way of resolving that emergency, even though, yes, it could lead to incriminating statements. And so because Quarles had sort of already decided that, I think that's the primary reason why that's not a concern.
How long,
Also,
excuse me,
yes.
Counselor, how long after this roadside chat was the child found?
I don't think there's any indication in the record how long that was, but let's see. We do know, so the roadside chat happened sometime after midnight, and by 8 a.m. they've located the girl, and the defendant has been taken to be questioned at the station house. So, roughly 8 hours.
Miss Lou, I have some questions as well. Here's what I'm wondering. There's a risk, I think, in writing an opinion in this case that we might create something called the kidnapping exception to Miranda. And I'm not saying whether I think that's a good idea or a bad idea, but just for the sake of sort of academically examining this case, beyond the mere fact of a kidnapping, which itself, I mean, I think I can see how that might suggest danger to the victim in and of itself. So beyond that, though, can you articulate or sort of crystallize for us what other facts, if any, suggest potential danger to the victim here?
I think in almost all cases, you're going to have an actual victim. You're going to know that somebody is in danger. And it could be like in quarrels where you have an unsecured weapon. But it's when you know that a shooting has occurred, like in the cases where they happen on the scene, they see bullet holes through the house, and they ask the suspect at that point, the later the defendant, what about the house? Do I need?
Well, but I think I'm asking more specifically about what you can tell us about this case. What other facts beyond the fact that there's been a kidnapping suggest that the victim of the kidnapping is in danger?
I think that's going to be implicit in any kidnapping. And just, we know from statistics, that the life of a child when they're taken, police officers need to work quickly because these cases often end in death for kids. And also sexual assault. That's also another huge risk to kids. So I'm not saying that it would be just the life of the child, but certainly the bodily integrity of the child as well is at risk.
So
Or
that
psychological damage, right?
That too.
That causes me to wonder, though, whether what you're asking us to do is to sort of create an exception, or at least maybe to decide that quarrels itself created an exception for every kidnapping case where there's been somebody who's legitimately been taken where they're not supposed to have been, somewhere where we don't know where they are. There's always the right in a police officer, when they have custody of someone they think might know, to ask without Miranda warnings, where is the victim?
I think in any ongoing kidnapping situation, when police have reason to believe that the defendant that they're just now talking to knows or could know where the location of the victim, I think the public safety exception will apply. That doesn't mean every kidnapping, because a lot of kidnappings will have already ended by the time the police are involved. But anytime they're involved in that short window of time when it's imperative that you ask questions to try to locate this victim, I think the public safety exception will apply.
Thanks.
One point on that, though, is that it's an objective test. So we don't want to get too much involved in the particular motivations of these officers in the scene. Their questions, again, have to be questions that, objectively speaking, would lead to the recovery of a victim.
Counsel, what about a situation where the police are investigating an ongoing criminal enterprise, like say drug dealing or something, and instead of asking, they stop somebody they know is connected to a larger drug organization, where's the meth lab? Why wouldn't they be able to do that? Because the meth, like meth could explode, the meth lab could explode. There's that if our motivations, or if we're saying that the threat is implicit, what's to stop us from implying in those types of situations, police can just basically ask these questions of these of a gang or something like that, and say, we know that you're dangerous, we know that you're a threat to the public generally, and we believe that we should be able to ask you these questions about where your main operation is, so that we can protect the neighborhood.
I think there'll still be a requirement, sort of imminency, that if the meth lab, the police have known that's been, in operation for a number of months, it's never exploded so far. I don't think that, that just the mere possibility that there is a meth lab out there would give rise to the public safety exception. And, later courts can can sort of draw these lines about what really is going to be imminent enough to qualify under the public safety exception. But when you have a known victim, like you have here, a very short time frame, that a kidnapping victim, the health and safety of that victim is at stake, then I think it surely applies here. So I'll end it there. Thank you.
Thank you,
Presiding
counsel.
Judge Keller, there you go.
The case is submitted and the court will stand in recess.